Hello, everyone. Welcome to Court with Krissy. I've got an update. And for those who had their boxers in a bunch because this first hearing ended with a fire alarm and no resolution, how do you like me now? You better like it. Court with Krissy is now in session.
We're asking that the court grant her request that Mr. Taylor not possess any firearms during his placement time, that he not use any controlled substances or alcohol 8 hours before any placement time or during placement time, and that Mr. Taylor anyway, or the parties, if the court feels it's necessary, submit to a hair follicle test. And I would ask that there's a very short turnaround on that.
Finish your argument so then we can at least leave.
That's all I have.
All right, well, I guess my decision's gonna have to wait because we have a fire alarm. So, I guess I wait to hear from me. Mr. Levens, I'll see you in a little bit. I'll see what's going on, okay? Thank you. We are adjourned. Ready? Yes. All right. We will go on the record in the matter 24 FA 53, in re the marriage of Alec Taylor and Melanie Taylor. Appearances are all parties appear by video conferencing. Alec Taylor appears, Melanie Taylor appears with counsel together by video, and we have James Bach also appearing. We were here back on September 18th, 2024 for a temporary order hearing, at which time the court did hear certain testimony from parties. Towards the end of the hearing, we did have an emergency fire alarm that went off. I believe that all parties had closed evidence at that time. However, before we proceed with an oral ruling, the court will ask the parties if there's anything else that they wish for the court to consider or any further arguments. Mr. Bach, is there anything further that you would like to place on the record or for the court to consider?
Not for a temporary order. Thank you, Your Honor.
Ms. Murtaugh.
No, Judge, thank you.
All right, thank you. This is a temporary order, and therefore it is apt to change and very well could change and could change multiple times throughout the duration of this divorce. The court did hear testimony from both sides. There is a restraining order and injunction issued in this case between Mr. and Mrs. Taylor. The court did hear testimony as to certain incidents that did occur between the parties, as well as testimony that Mr. Taylor did violate the restraining order on various occasions. As the court understands, there are criminal charges that were filed in that matter. The court is not taking that into consideration because those are just charges, and Mr. Taylor is innocent unless proven guilty. However, in this type of court, the family court, those allegations can come into the matter because it is a lesser burden. So the court can at least consider those and can consider those in this type of hearing and matter for a temporary hearing. Ms. Murtaugh did argue that the court should consider under the statute domestic violence issues and the fact that there were incidents involving domestic violence involved between the parties, and that some incidents may have occurred in front of the minor child, and in fact that may have also occurred in front of Mr. Taylor's other child that he has with another individual. Mr. Bach did argue that the court in Mr. Taylor's other case with another mother of his child found him fit for legal custody and for placement of the child. However, the court does take judicial notice of that case, and the court finds that that matter was reached by stipulation of the parties and that the court did not have a hearing in that matter. So the court did not itself find Mr. Taylor fit in any legal sense for legal custody and or placement. The court has concerns as it relates to any allegations of domestic violence and any mental health issues as raised by Ms. Taylor. Therefore, at this time, the court is going to temporarily, and again, this is only temporarily, and the court does not take this lightly. The court is going to temporarily order joint legal custody, or excuse me, sole legal custody to Melanie Taylor and sole placement or primary placement to Melanie Taylor with supervised visitation to Alec Taylor. Supervised visitation will occur with Alec Taylor with one of his family members, and the court is ordering a mental health evaluation to occur within the next 45 days if he can get in for a mental health evaluation. If he is not able to get into a mental health evaluation, then the court must be notified there so that the court can adjust the order. The court has concerns again about Mr. Taylor's mental health, and especially as it relates around the minor child at this time with the incidents that have occurred with Ms. Taylor and or with Ms. Taylor's family members. The court is going to get a guardian ad litem appointed as quickly as possible, even without having mediation, because this is a case that the court believes a guardian ad litem is needed as quickly as practically possible, so that the child's best interest can be assessed and addressed quickly. The court will, Mr. Taylor, do you have family members within Burnett County?
I do not, but they can be.
How close do they live?
Just across the border in Minnesota.
The court will, do they work?
Yes, ma'am.
Do they work on weekends?
Sometimes, yes.
Well, I'm looking at having visitation with the child every other Saturday and every other Sunday from 9 o'clock until 5 o'clock. And perhaps a Wednesday from 5 o'clock until 8 o'clock on Wednesdays, or every other Wednesday if that can be accommodated from with your family.
Yes, ma'am. My mother will be available anytime.
The court would like to have another hearing as soon as the mental health assessment is done, and that the guardian ad litem can have a first go around of investigations, and to have a home visit with both of the parents. I am open to suggestions of guardian ad litems, or I will appoint one myself.
Your Honor, I think it's best if the court just appoints one that's either on Burnett County's list. However, the court does it under contract.
All right, then I will do that and I will have one appointed. You will get notice next week. Was there anything else that we needed to discuss for a temporary hearing?
Your Honor, my only question is when to start the supervised visitation, 9 a.m. to 5 p.m. every other Saturday, what Saturday that would start specifically? And then I would imagine the court is saying the weekend that he would not have the child would be the Wednesday. Is that what the court meant? 5 to 8?
Yes,
Okay.
yes, yes, thank you.
And Your Honor, would you like to schedule 60 days out that second hearing or longer based on the appointment of the guardian and the statute and the 120 days and all that? How quickly would you like to do that before Thanksgiving?
I am not sure how long it's gonna take the guardian ad litem to do home visits and to meet with the parties, but if councils wish to schedule the hearing now, I can do so.
My only point, Your Honor, is I think it would be that is 7.5, almost 8 weeks. I think if there was a hearing between the 22nd and the 26th of November, that's going to be well past the 45 days to have the evaluate and do that. And the court's going to appoint a guardian next week. So that's 7 weeks to conduct the preliminary investigation. We're going to get into the holiday season, Your Honor, and I know how busy the court will be and how everybody else is busy, including a third attorney, the guardian. So I'm just hoping we could have the hearing that you'd like before the 27th.
I wouldn't be able to set a hearing until I have a guardian ad litem appointed anyway.
Okay, that can be arranged after the appointment, Your Honor. Thank you.
Ms. Murtaugh and Ms. Taylor, any problem with it starting this Saturday? Because I'm going to presume Mr. Taylor has not had an opportunity to see the child in some time.
No, no objection to that, Judge.
So it starts this Saturday.
Thank you, Your Honor. Just so we're clear, that's 5, 6, and then the 9th is the Wednesday, and then it would be 19, 20, and the Wednesday of the 23rd, and continuing on that rotation. Is that correct?
I think it should be 5, 6. And then the 16, wait. Or I'm fine if he has her every Wednesday, 5 to 8.
Thank you, Your Honor. That'd be fine.
If that can accommodate. If his mother can accommodate 5 to 8 every Wednesday, well, 5 to 8 every Wednesday.
Mr. Taylor?
Yes, she can.
Or what is the child's bedtime? Maybe that's too late.
She usually goes to bed around 8:30.
So that should work.
Yes, that'll be fine.
How about 4 to 8? Does that interfere? Because that's a good solid 4 hours.
I am usually getting off work at 4 on Wednesday.
All right, we'll just keep it at 5 to 8.
Thank you, Your Honor.
All right, as soon as I get a guardian ad litem appointed, I will have my assistant get a date set so we can have a hearing set, so we can at least have a review of the temporary hearing, but the court is going to need to have that mental health assessment and report done so that we have that accessible for the hearing.
Judge, I just have a couple questions. Can the court define the level of supervision that needs to happen? I mean, eyes and ears, or just in the same house?
I think same house, not letting him, the same house. I don't think it needs to be 24-hour eyes on or same room.
So supervisors just to be in the same location?
Yes.
And then also, does the court want to make an order on how the child will be transferred or exchanged?
Yes, that is probably a good idea. Probably meet at the sheriff's department.
Are you okay?
Yep, that's fine.
Both parties meet at the sheriff's department for each of the exchanges.
So will she exchange with whoever his supervisor is? Is that your question?
Yeah.
That could work just fine.
Okay, well, I mean, just because of the injunction, I think we just need to be cognizant of that issue, so.
Oh, there's a camera. And I'm gonna presume they're not gonna come alone. And there's usually sheriff's deputies present at all times.
Your Honor, I would specifically request that the court write that into the order exactly as opposing counsel articulated or envisioned. My client would be coming to the Burnett County Government Center in the Sheriff's Department slightly
Not
prior.
in, just outside, because they'll be closed on Saturday.
Correct, Your Honor. Thank you. What I'm saying is it would be a violation of the harassment restraining injunction. And so I'd need the court to annotate in this family law order that that exchange with the supervisor, even though my client is in the parking lot, is not a third-party violation of the.
Well, as attorneys know that the government building, all government buildings are a neutral zone. It's what the law says. Government buildings are a neutral zone. So I would presume then that the sheriff's department is also, since it's attached. And if you want, just have the supervisors go and exchange the child.
I think that if Mr. Taylor is with during the exchange, it would probably just be a good idea for him to stay in the car and then his supervisor and Ms. Taylor can exchange. I think that would probably be the safest for everyone.
That works. I'm also ordering Mr. Taylor to do the domestic violence education group with restorative justice, Dave Hatch, here at the Government Center. That is to be completed within 30 days. Oh, it's a 4-week program. So I guess I'll say that needs to be completed within 60 days. So.
Sounds good. Did you want me to draft, Judge?
Yes, please.
Sounds good.
And again, once I get the guardian ad litem appointed, we will get dates out so that we can get the next review set. Anything further that we should address today?
Not from my perspective, Judge.
No, thank you.